Very good.
And Paul Schwartz. I'll start when you're ready.
All set.
All right. Thank you, Madam Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 290. House Bill 290 allows for the lawful intercept of wire, oral, or electronic communications in cases of imminent danger and as admissible as evidence for specific crimes. What if your family member was a victim of a horrific crime? A crime that was recorded, a crime that objectively happened, but justice would never be served because the only evidence you had was a recording. And the only purpose that recording serves was to traumatize the victim over and over again. You see, Maryland is a two-party consent state. That means you must have the permission of other parties who may be recorded. This leaves any recording as inadmissible as evidence. House Bill 715 attempts to fix this problem, and it does so by making an exception in our interception law that allows for the lawful intercept in cases of imminent danger of a crime of violence, stalking, abuse, or a violation of a protective order. This bill simply makes it lawful to record if a person has a good faith belief that they or another person will be a victim of the specified crimes. I would like to remind the committee of a shocking statistic revealed to us this session. Approximately 6% of all rape cases are prosecuted, and approximately only 1% achieve a conviction. While those terrible numbers have many root causes, a significant cause is the fact that to prove the burden of the crime requires evidence that in some cases only exists in the form of a recording. We should reform this law with those victims in mind. Thanks for the opportunity to present House Bill 290. Be happy to take questions, and I'd ask for a favorable report.
Before we start with the next witness, I just want to make sure that we are clear. We're talking about House Bill 290. I think there was perhaps a mistake, misspeaking of House Bill 715, perhaps from last year or something.
Yep, you're right. It's 290.
Okay, great. All right. Ms. Jordan.
Good afternoon, Madam Chair, members of the committee. I'm Lisa Jordan from the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 290. Thank you, Delegate Grammer, for continuing to champion this bill. You know, this is an important bill for rape survivors. A lot of sexual assaults happen in private, and at AMCASA, we're aware of at least 3 cases where someone has had the presence of mind to take their phone and make an audio recording of the assault. So we're not talking about an admission afterwards, but actually of the assault. And those rape survivors, they're felons. And that evidence cannot be used in court. House Bill 290, it's well-tailored. It allows admission of tapes of rape. It maintains privacy by keeping the other parts of the statute in place. For these reasons, I see I'm very close to out of time. We urge a favorable report on House Bill 290.
Thank you, Ms. Jordan. And actually, your time was probably fine. The clock wasn't working, so you're fine.
Oh, may I finish? I'll be very quick.
Very briefly.
Yes, very briefly.
Okay.
Just let me say that several things were revised since last year when you heard the bill. One, there are no special rules in the bill this year. The rules of evidence will apply. That, I believe, the judiciary didn't object to the bill this year, so I suspect that could be why. It addresses the concerns that people had about exposing survivors to criminal liability, and the felony penalties that could affect those survivors by requiring a good faith belief the crime would occur, not something that needs to be judged on a reasonable person basis. And finally, I know that my dear colleague is going to suggest an expansion of the bill to cover assault too. AMCASA absolutely believes that's good policy, but I will make the observation that the colleagues you have across the street are likely to go the other way and narrow the bill. So the committee may want to consider that. We're comfortable with the bill as drafted. Thank you.
Okay, thank you. I'm going to go with my timer here. I think Ms. Shapiro, are you next, or whoever wants to go next?
I'll go.
Okay, thanks.
Thank you, Madam Chair, members of the committee. Melanie Shapiro, I'm the Public Policy Director with the Maryland Network Against Domestic Violence. We are the federally recognized state domestic violence coalition. And as Ms. Jordan indicated, I am here with an amendment. I am greatly appreciative of all the work that has been done on this legislation to get us to the point where we are all here in support of this bill. The good faith belief and imminent danger language is very important. The small amendment that I have is to change the crime of violence definition to include the public safety article definition found in 5101. The reason for that is that it includes assault in the second degree, as opposed to the abuse language, which is in the bill and also important. There are many domestic violence relationships that would not be encompassed with that assault in the second, without that assault in the second degree being included. For example, the protective order statute definition requires that you be in a sexual relationship with an abuser within the past 1 year to be eligible for protective order. It is narrowly tailored, and it rightfully so, because of the expansive protections available under the protective order. However, if you have been in a relationship and dating somebody for 6 months and it's not sexual in nature, this would not apply. And so you could be abused, you could record it, and you would be prohibited from doing so. I don't believe you'll be a felon based on how it's drafted, but I do think that that expansion is important. I also think that passage of HB 290 is crucially important to allow victims and survivors to enter what is the recordings of the victimization that has occurred. And so for all those reasons, we are urging a favorable report with amendment on HB 290.
Okay, you still had 19 seconds, so very good. I'm gonna start the timer again, and yes. You think you're back?
Okay.
Okay, great. We'll
My
start.
name is Paul Schwartz with the National Active and Retired Federal Employees, NARF, and we strongly support passage of HB 290. We are in the electronic age, and not to fully use our electronic capabilities to protect the vulnerable among us is an abdication of the government's responsibility to protect its citizens, specifically our children and our elderly, two groups that often rely on home care services. It is not uncommon to hear about elder abuse or child abuse. This bill simply attempts to address an oversight in our laws by authorizing single consent to intercept a wire, oral, or electronic communication if the person has a good faith belief that an individual is in imminent danger of becoming the victim of a crime of violence, stalking, abuse, or protective order. To me, this is a no-brainer. If that person fails to demonstrate a good faith belief via evidence, then that person will be in violation of this law. Currently, there are 35 states, the District of Columbia, and the federal wiretapping statute that requires one-party consent. We, Maryland, are in the minority. Imagine, if you will, if Georgia, the state of Georgia, required two-party consent. Just think about that one. And I think that's my closing. So this is the intent of this bill, is to protect the abused over the abuser. Thank you.
Okay, Mr. Cox.
Thank you, Madam Vice Chair. John Cox, Deputy State's Attorney for Baltimore County, and speaking on behalf of the Maryland State's Attorneys Association in support and asking for a favorable report on House Bill 290. The issue primarily has been addressed. I just want to give you an anecdotal example of the impact that this has. It was a domestic violence situation and a rape of a woman. And in that circumstance, she sadly had learned the pattern of her abuser and knew when the next attack was going to come. And by the way he was behaving, she knew it was coming. She activated her phone and the auto recording. She was raped, and then that was recorded. And without this, that recording is not admissible in a courtroom. And in fact, in that particular case, that victim, having drawn up the courage to come in and testify about what happened to her on that day, was surprised by the fact that when she took the stand, the defense attorney is saying she ought to have a lawyer because she's committed a crime. And so now we have the victim of a rape up on the stand being subjected to that trauma of wondering, should I really be here? Do I need a lawyer? That's an outrageous circumstance that individual has been placed into. And then it puts us and the state's attorneys in the very awkward position of trying to assure her she's got nothing to worry about. We're never going to charge her with that, but it is a crime. And then to make her feel better, we can exercise our power of granting her testimonial immunity, which is ridiculous. Now the jury hears that this person has been granted immunity to testify about having been raped. That's something that just should not happen. We need this to protect the victims.
Good afternoon, Madam Vice Chair, members of the committee. My name is Amanda Rodriguez. I am the Executive Director of Turnaround, which is the Rape Crisis Center and a comprehensive domestic violence and human trafficking service provider. My title is getting longer, I think, every time I come before you, for Baltimore County, Baltimore City, Howard County, and we are a week and a half away from opening the first home for child trafficking victims in the state here in Anne Arundel County. I'm also the chair of the Legislative Committee of the Maryland Human Trafficking Task Force. This bill in particular, I did not know it was coming, but when I heard that Delegate Grammer had introduced it, I was overjoyed. At Turnaround, we've seen at least a dozen cases of abuse, which was caught in an audio recording. It spans from everything from intimate partner violence, both recorded by the victim themselves, but also the victim's children who are capturing the violence on their cell phones. We have stalking incidents where people are capturing that on their phones and not able to introduce that as evidence or to use it in any way. And then also rapes, which have been captured in their entireties. We have seen that primarily with our college campuses or clients who are on our college campuses. The best evidence of what actually occurred is not only not admissible, but also makes the victim a felon, as you've heard, for recording the assault. We have to advise survivors who took the very logical step in the moment of intense trauma to hit the record button, that the evidence is both not admissible, both in criminal and in protective order hearings, and that no one can ever listen to it. That the risk that they took in that horrific moment that potentially could have risked their lives simply was not worth it. Based on this, we are asking for a favorable report. Thank you so much.
Thank you. Are there questions? Delegates Simpson, Erican, Conaway, Pasteur.
If amended, are you willing to add a change in one word of making it from a felony to a misdemeanor?
I knew you were going to ask this.
You did?
I did. So I wrote this down. So there's been, Madam Chair, there's been a great discussion about reducing the penalty, eliminating the penalty as a way to deal with this. Let's just make this an open party state. I wanted to put into context the conviction, what we're talking about here. In 2022, there were 42 allegations statewide of illegal wiretapping and 0 convictions.
Mm-hmm.
In 2023, there were 43 allegations of illegal wiretapping and 1 conviction. So I'm fine with changing the penalty from a felony to a misdemeanor, but I don't think it gets at the nature of the problem. And I would ask my panelists, how many rape cases are there statewide where we can't prosecute an offender because we can't admit a recording of a rape that was recorded by the victim? I mean, do you ladies want to comment on that? How many hundreds or thousands of cases?
So thank you, Delegate. I don't know that I would say hundreds and thousands, but I will say that originally someone came to me and said, I've got 1, and now we're up to 3. And now when I talk about this bill in community forums, it is always the case that someone comes up and says, yes, this happened to me. Yes, I have this case. Yes, I prosecute in this jurisdiction. We have them all the time. So we all have cell phones. We even have cell phones up here at the table.
Right.
Mm-hmm.
You know, I mean, this is happening. Rape survivors are thinking in the moment and trying to do something to document the terrible thing that's happening to them. So it's certainly a real problem that you really should solve.
So I'm open to a conversation, but I think the victims should come first and foremost here.
Delegate Erican.
Thank you, Madam Chair. Thank you guys all for being here and for bringing this bill. My questions to the state's attorneys. If the recording was made in a single party recording state, could it still be used in a court in Maryland to prosecute for anything or even in a civil hearing?
I believe so, yes.
Okay, is there a statute that you're aware of that lays that out?
I'm sorry.
Is there any specific statute to look to? I'm just trying to understand how it works when you're going.
I
between two
honestly don't
states.
know. I don't think that there wouldn't be a statute that would address the admissibility.
Okay.
Not that I'm aware of. Obviously, we rarely face that circumstance because odds are the crime didn't happen in Maryland.
Right, if it was like sort of on the edge, crossing multiple places and they got some recording on one side and, you know, people transfer a lot between West Virginia, for example, and Maryland. So just trying to understand if there's any way to get, you know, other states that have different policies, that evidence entered lawfully. It was recorded lawfully, but obviously it's would technically be inadmissible, I'd assume, but maybe not, is what you're saying.
I'm only guessing because I haven't had to address that particular issue, but my best informed judgment would be that if it wasn't recorded contrary to the law, and it would be contrary to the law if it happened in Maryland.
Right.
But if it was somewhere where it was not contrary to the law, I don't see a reason why that would not be admissible.
Okay, thank you very much.
Delegate Conaway.
Thank you, Chair. Thank you, panel, for coming in to testify today. Someone on the panel said that you can't use one of these, video recording in a stalking case. Does anybody remember that? If you're being
You can't use
stalked.
it in anything right now.
So if someone was stalking a person's dwelling and the person that owns the dwelling takes the picture of someone outside stalking them or video, they can't submit that?
So I'll briefly retell the story why this issue came to me. So I know a couple of young ladies who are married in my district, and they had some very toxic circumstances around where they live. The neighbor would do everything to make their lives completely miserable. And they wanted some relief. They wanted to get a protective order. So of course they whipped this out and recorded him. And that none of that's usable. So it doesn't matter the crime. In that case, it was probably harassment, maybe something that could be considered a hate crime, but it doesn't matter right now. Any recording technically is a crime, and any recording is inadmissible in any hearing.
If I can jump in just briefly, the video would be admissible, but not the audio.
Correct.
Right. So now, in the cases where you did have video and audio, but you only used the video, did you also have forensic evidence that there was some sort of DNA transference in these cases? Where you're saying there were rapes? I mean, was the whole rape case depending on this video audio footage, or you had other evidence?
Well, I don't mean to belittle at all the main evidence, and that was the victim. She certainly can testify as to what happened to her. I don't have a recollection of any other forensic evidence. But obviously, as we heard the statistics from Delegate Grammer, our ability to succeed in prosecution is only bolstered by very credible evidence, in addition to the presumably credible evidence of the victim. And that would be a recording of the crime itself.
And let me give you an example. So you have a girl who reports a rape. There is a DNA kit. It identifies a male, but the male says it's consensual. Well, if I'm not mistaken, the law regarding rape requires you to present evidence of force. Well, it's he said, she said. And I think that is one of the underlying problems of why it's so hard to convict a rape case, because it's beyond a reasonable doubt. You have to prove it was force in a rape. And how do you do that?
Well, I think that's pretty good, Delegate. That's very, very nice. You and I have been here at the same amount of time. But I think that the rape can also happen after you withdraw consent. So that is somewhat of a extreme example that you're given. All I asked is if there was other forensic evidence, and was the lack of the ability to use this video recording, was that hindering law enforcement's process? So thank you very much.
Thank you.
Delegate Pasteur.
Thank you, Madam Vice Chair. Thank you for bringing this to us. Up to this point, you have specifically spoken about sexual abuse and violation. So you might know that Senator Hettleman and I did a task force last session on elder abuse. And as a piece of that, the case that came to me first, which catapulted me into that. And I'm giving this little piece to ask if this would cover this situation. So it was a matter of a parent being abused physically, but in a way that some of it was covered, not being fed, and a lot of verbal abuse. This was at the hands of one of the children. So the sibling was sure that this was happening, but couldn't prove it. So at the hands of this particular one, so she hid a recorder and had in another spot a video so you could see some things, but just the things that were said in conversations. And the mother was very weak, very feeble. So you couldn't hear, or well, you could hear. So my question is, with this bill, would all of that been admissible? Because you can hear what is being said to this person as well as seeing some things
So this,
or not.
this bill,
Because it was being done by a third party versus the victim.
this bill in its original form was brought by JAG for that specific problem. Elder abuse, they're either with a relative or they're in a retirement community. There's verbal, mental, physical neglect issues. And how do you prove that without recording it? Because you can't be there. That's why they're in that facility. So that issue was at the original intent of the bill. I believe is drafted, we've caught that. I'd be happy to work with the committee to ensure of that. But this whole issue of what crimes to which the bill applies that's where the crux of the discussion seems to be. And I'd be happy to work with the committee to make that happen.
Delegate, if I may.
Sure.
Thank you. That's an excellent question, Delegate. Thank you for that. I think it's possible that particular situation would be encompassed in the definition of abuse in 4501 of the family law article, because that does apply to vulnerable adults. It does matter who is, so it should be encompassed in there. I think an assault 2 would not, as drafted, it would not include that if it didn't qualify under the abuse definition in the family law article. So I think the intent would be for those situations to be included. I think the challenge has been to narrowly tailor the bill so that it can at least proceed in some fashion at this point, which has been the general sentiment that we've gotten in terms of prior versions of this legislation. I would think that would be included, though, in the definition of abuse.
Because the task force is only a task force and nothing else. Our intent is to figure out where the crimes are so we can then process what we need to do to be able to prosecute or hold people accountable.
We need the help of you and the rest of the committee on that.
Thank you.
Thank you. That concludes this panel.
Thank you.
Thank you. And Melanie Shapiro already testified under favorable with amendment. So we'll move to another group of panelists. I see Debbie Feinstein coming up, and is Lindsay Carpenter. Oh, that's great. Anita Bailey. Anita Bailey.
Right here.
Okay, great. Okay, in whatever order you want to start, we're all set.
Okay. Good afternoon, Madam Vice Chair, members of the committee. My name is Lindsay Carpenter. I am the Chief of the Special Victims Unit at the Frederick County State's Attorney's Office, and I'm here asking for a favorable report. I did submit written testimony. However, I did want to provide you guys with a few case examples. I've had 2 physical child abuse cases where we've had this situation. One involved a 13-month-old victim that was physically abused by his biological father. The mom had been concerned that there may be abuse going on, so she had mentioned something to dad's roommate and had asked to document anything if he saw anything. Unfortunately, something did occur and he did document that. Now, when that case goes to trial, certainly the 13-month-old can't testify as to what occurred to him. And the only evidence would be this individual testifying to what he observed, and then father's testimony. Again, a he said situation. If we had that video or that audio evidence, it would help that case. Another case was a physical abuse case. It was a 7-year-old child who was being physically abused by her biological father. Her 13-year-old sister hid under a table and audio recorded that abuse as well. So I just want to put forward that there are these cases that are occurring. And when we have these victims testify, we want to be able to support their testimony with credible evidence so it doesn't become a he said or she said versus an opponent's statement. So therefore, I am urging a favorable report.
Thank you. Ms. Feinstein?
Thank you. Good afternoon, Madam Vice Chair and members of the committee. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. Lindsay and I have the same, or Ms. Carpenter and I have the same role in different jurisdictions, and we see a lot of the same things. So I don't want to repeat what she said. I can tell you that I have numerous examples of exactly the same situation: assaults that have been recorded, rapes that have been recorded, domestic violence, any variety of sort of violent crime that have been recorded, and we've been unable to use them. Just this week, we have a group through the MSAA of prosecutors that handle special victims type cases. And just this week, I got an email that asked what this person was going to do. There had been a recording made, an illegal recording made of an assault, and it contained the defendant's statements. And what the prosecutor said was, well, it would be illegal for her to retain a copy of this recording, but at the same time, the defendant has the right to hear his own statements in case the defense wants to argue that they're exculpatory. So it kind of puts us in a trick box, and one that really shouldn't be a box at all, given that it was a recording, the best evidence, as was said earlier, of a violent offense. And this law, switching it to a subjective standard versus an objective standard, makes every sense. And we would ask you, and I would urge, a favorable report on HB 290.
Good afternoon, Madam Vice Chair and members of the committee. My name is Anita Bailey, and I am asking you to give HB 290 a favorable report. Based upon my personal experiences as an attorney practicing in the areas of family law and domestic violence for more than 26 years, I believe that this bill will greatly benefit victims of domestic violence, among others. I am currently the Chief of Legal Assistance at Fort Meade, and the main service provider for Fort Meade's Domestic Violence Victim Representation Program. Although I am not here representing the position of the U.S. Army or the Department of Defense or the United States government. This is in my personal capacity. Prior to joining Fort Meade, I was the chief of Maryland Legal Aid's Anne Arundel County office, where I practiced for 22 years. I have counseled and or represented many victims of domestic violence fearful of or unsuccessful in obtaining protective orders or pursuing violations of protective orders due to a lack of admissible evidence. Abusers are controlling. They make the victim dependent on them, and they undertake efforts to isolate them from their other support systems. Abusers rarely commit acts of violence against a victim with witnesses present. Often the only evidence and the best evidence is an audio recording that the victim may have made. This creates and being that it is not admissible, it creates a chilling effect on victims who fear further reprisal if they're not successful in court. The fear also makes the victims poor witnesses in court when they are facing their abusers and not as credible as their abusers might be. I want to just highlight two recent instances where a recent client of mine did have an audio recording and was unable to pursue a protective order because that was the only piece of evidence she had. And in another circumstance, there was a domestic violence related court-martial case at Fort Meade. The abuser was charged with multiple criminal charges, and some of these charges were supported by audio recordings. The convictions that were obtained where there was audio recording support that was admitted into evidence, and the other charges were not upheld. So that just proves that there is, those audio recordings are quite powerful in that court proceeding.
Thank you.
And that's why I'm asking for a favorable report.
Thank you, Ms. Bailey. Are there any questions for this panel? All right, seeing none, that concludes, nope, not quite. We have opposition. That concludes this panel. We have opposition virtual. Mr. Vince McAvoy.
Thank you, committee. I appreciate hearing me on this bill. As I wrote and written, the construct of this bill is unacceptable. It allows wire intercept and transmission interceptions ad hoc based on hearsay and emotion. That's what it means. A good faith belief that a person is what's actually being substituted when you look at what is in the prior parts of this bill, which says that it is lawful for a wire electronic communication officer's employees to provide information. It is lawful under section 2, subsection II, for investigative or law enforcement officers acting in a criminal investigation for the commission of what? Murder, kidnapping, number 3 is rape, 4 is sexual offense, child abuse is number 5, child pornography, etc. We already have this. This bill is not about helping anybody, and this bill won't help anybody. I was in Baltimore City child support. I've had to use locate features to find criminals, people out in the streets. We're letting criminals go. If you want to stop rape and all these other things that you listed, stop letting them go. However, this bill is about using the most amorphous, sort of made up categories of the sections that you see on page 2, 17 to 22, to say that basically a person, and under these very nondescript ways, we're going to let anyone record anything. And incidentally, you can't do that in Maryland because we're not a two-party, we're an all-party, which in other words, anyone captured in there is subject to those wiretap issues. This bill is not about helping people. This bill is about denying 4th and 14th Amendments for individuals. Urgent unfavorable. There's another way to skin this cat. If you like to talk, ask me questions.
Thank you. Are there any questions? Seeing none, that concludes the testimony for House Bill 290. Next, we're going to have Delegate Simpson with House Bill 274. Delegate Simpson, do you have a panel with you? Elizabeth Hilliard, John Cox, Melanie Shapiro, and Aaron Pearl. Delegate, whenever you're ready.
All righty. Good afternoon, everyone, especially Madam Vice Chair. I'm here to ask again for a yay vote on 274 intercepted communications penalty. This bill was previously introduced and passed through this committee in both 2022 and 2023, but unfortunately was held up in the Senate both years. And so just for our newest member, just to be aware, all this bill does is change one word, makes it a misdemeanor instead of a felony, which I think is significant, as we heard in the last House bill, is that it's just one of those things that people would be more likely perhaps to report if they knew that it was not actually a felony, but instead was a misdemeanor. And we do believe that it will make a difference for victims of violence. Also, I think most of us, I know not all, have smartphones and are not aware that when we are videotaping someone and we didn't get explicit permission, that we would be breaking the law. So I do think this is one of these things. Let's just get modern. With that, as I said, please remain steadfast. With that, I humbly request your favorable report on House Bill 274. And I want to make it very clear that I fully support, if this committee so chooses, to combine House Bill 290, our Delegate Grammer's bill, with this, and just make that one little change. If you're already making other changes, just switch it out. Thank you.
Good afternoon. I'll probably be the briefest one here today on behalf of this bill. Aaron Pearl, on behalf of the Frederick County State's Attorney's Office. I'm an Assistant State's Attorney there. And on behalf of J. Charles Smith III, as well as the Maryland State's Attorneys Association, we support this bill. Thank you.
Frederick in the house.
And having heard already the support of the Maryland State's Attorneys Association, I don't need to say much more. after having heard that you've passed this out of this committee before, but obviously the State's Attorneys Association is asking for a favorable report.
Ms. Shapiro?
Thank you. Good afternoon, Madam Vice Chair, members of the committee, Melanie Shapiro, Public Policy Director with the Maryland Network Against Domestic Violence. I would just note that sitting on this panel is both a victim service provider, State's Attorneys Association, and the Office of the Public Defender. And so with that, and for all of the reasons on HB 290, looking at it holistically, in addition to HB 274, we are in favor and ask for a favorable report on House Bill 274.
I can just take Melanie's remaining time. Vice Chair, members of the committee, as Melanie pointed out, how rare is it to see all of us here together? We're always in favor of reducing a felony to a misdemeanor. We have slightly more complicated feelings about Delegate Grammer's bill, but we certainly support this wholeheartedly and would be willing to work on marrying the two. Absolutely.
Great. Take a picture, folks. Delegate Conaway.
Thank you, Madam Chair. Thank you, panel, for coming in. So to the good delegate, I have a question. Is it factual that the actual act of recording people in public is illegal or somewhat restricted?
It's restricted if you don't have it. We're a two-party state, so we would have to have their permission if we were gonna probably post it, not necessarily just
No, but
taking.
I didn't ask about posting. So let's say people having a protest outside Lawyers Mall, can I record them or I'm doing something illegal because they're in public?
I'd be happy to jump in there.
Yeah,
I'm gonna say, I'm gonna go with the people that would do the prosecuting.
Right. There's a distinction between whether or not it's a phone or phone call or just an oral transmission. Speaking and obviously right here where this is being recorded. So if it's a phone call, never. That's a crime to have recorded that. If it's a oral transmission, it still requires for it to be illegal that person being recorded have an expectation of privacy. Somebody out in a protest probably doesn't have that.
Right. So, but if you just happen to walk by someone who's they're talking loudly on their phone and you're just recording and saying how wonderful a place is, you haven't done anything illegal, have you?
In my opinion, you have not.
Thank you so very much.
Great. Any other questions? Seeing none, that concludes the testimony for House Bill 274.
Thank you all very much. Appreciate it.
Okay, we're gonna move on to our last bill of the day. Delegate Pippy, come on down. This will be House Bill 288, Delegate Pippy. And do you have a panel with you?
I think I do.
You do. Okay, so we've got Debbie Feinstein, Aaron Pearl, and I think Lisa Jordan.
Ms. Jordan had to step to a meeting. I've got her position as
Okay.
well. Thank you.
Okay, great. So Delegate, whenever you're ready.
All right. Judiciary Committee, Madam Vice Chair, Delegate Pippy here in support of HB 288. So just a brief history, this committee passed this bill unanimously last year in the exact same posture it is here today. You actually passed it unanimously the year before that in the exact same posture it is here today. Your majority leader, I should say the majority leader, when he was vice chair of Judiciary, actually worked on the language of this bill with the consent of the committee. It was actually passed in JPR 2 years ago as well, unanimously. Last year, I had it cross-filed in the Senate with who our current Secretary of State is. And so I think what occurred after it passed this committee, went to the floor, passed unanimously, is it just something happened to it. But we're back. Proud to say we have a cross-file with Senator Wallstreicher, who's the vice chair of JPR this year. This is what this bill does. So currently, this committee has increased penalties for those that create child pornography, which is obviously it's a good thing to do. We found a loophole, and the loophole is that if an individual places a camera, let's say in a dressing room, and videos children in compromising positions, that is a very, very minor offense. And so what this bill does, it increases penalties. It does not make it a felony, but it does increase penalties for those that take videos and camera shots in an inappropriate way, is defined with prurient intent, which means for inappropriateness. And it's a great bill. Hoping to just move this through easily this year. Cleans up some other language, but with that, happy to turn it over to my colleagues here. Thank you.
Thank you very much. Good afternoon again. Erin Pearl, Frederick County State's Attorney's Office, and again, also on behalf of the Maryland State's Attorneys Association in support of this bill, House Bill 288. I am an Assistant State's Attorney in the Special Victims Unit. Our office has had numerous cases involving cameras or cell phones being surreptitiously placed to capture naked children. One of my very first trials in the district court, some 16 years ago, involved an adult male in the American Eagle dressing room, placing his cell phone under the stall next to him, attempting to capture nude images of 2 female children. The penalty for the offense at that time was 1 year. It has remained unchanged, despite the fact that computer forensics have shown these types of images are manipulated for the pleasure of predators, maintained for their collections, and utilized for distribution. Our office has previously charged production of child pornography in many of these cases. However, not all of these cases meet the nuances in the definition of lascivious display in our child pornography production statute. We also have to be concerned about precedent out of the District of Columbia. The DC Circuit Court there in 2022 vacated production of child pornography counts involving a surreptitious recording of a minor naked child in her bedroom and bathroom. There is no justification for the huge disparity in the penalties from the current 1-year misdemeanor for this visual surveillance and the 10-year felony for production of child pornography. This is nearly identical conduct. This bill also includes a residence and a place of private accommodation in the list of private places, closing a loophole for predators operating in this environment. I implore this committee to issue a favorable report.
Good afternoon, Debbie Feinstein, again from the Montgomery County State's Attorney's Office, Chief of the Special Victims Division. My division, like Ms. Pearl's, also prosecutes cases involving child exploitation, production of pornography, and sexual abuse of a minor. I want to highlight one case from a couple of years ago where an individual placed a hidden camera in the bathroom of a gymnastics studio or gym where young children were changing into their gymnastics costumes and recorded them, retained them, used them for his own purpose. Now, if that same person had recorded their child at home in the bathroom, they could be facing a penalty of up to 25 years for sexual abuse of a minor, for exploitation. Visual surveillance, as you've heard, only carries 1-year penalty. There's a huge disparity, and really it's an access to justice issue for a child in that gymnastics studio should be in the same situation as someone in their home environment. Those 2 children were victimized in the same way. Recordings of them changing in various states of undress or naked being retained by the perpetrator. I would urge a favorable report for HB 288. Thank you very much.
Thank you. Are there any questions? Seeing none, that concludes the testimony for House Bill 288, our last bill for the day. So that concludes the work at the desk. We are adjourned.